I'm Alice O'Brien. I'm on the board of the American Constitution Society, and I'm really pleased to welcome you to today's conference. You all know that the American Constitution Society is one of the leading national organizations promoting progressive constitutional debate and theories and arguments across the country through a diverse network of practitioners like myself, academics like many of the people on this panel, and law students as well. And today's program is very much in that tradition and very timely. You know, we have all just come through one of the most consequential midterm elections in our lifetimes, where the voters decisively rejected the big lie in many places, decisively stood up for rule of law and democracy in many places. But those elections were hard fought and narrowly won in many places as well. And they were won on a battlefield which is awash in money, awash in dark money, and sort of on a chessboard set with a Trump-stacked Supreme Court, which is undermining rights that we have all come to hold dear over the course of our lifetime. Professor Fishkin and Forbath's scholarship and their book, The Anti-Oligarchy Constitution, provides a really important, I believe, vantage point on our current constitutional moment and how we can structure arguments and who we should be addressing those arguments to in order to advance opportunity, advance democracy under our constitutional structure. In my day job, I'm the general counsel of the National Education Association, which is the largest union in the country. We represent 3 million educators across the country. And our interest in advancing economic opportunity and educational opportunity has always been advanced largely outside of the Supreme Court of the United States, because that is not where you go to make those arguments. And I think the professor's book, you know, provides rich additional ways to think about how to make those constitutional arguments, who to make those constitutional arguments to, that are particularly exciting and interesting for organizations like NEA that are interested in advancing educational opportunity, economic opportunity throughout the country, and organizations like the American Constitution Society, which is dedicated to promoting progressive constitutional thought and ideals. Without further ado, I'm going to turn it over to Joey, who's going to welcome you even more gloriously than I have. I do want to thank the Georgetown University Law Center for providing the space for this event, and the Hewlett Foundation as well for sponsoring the event. Thank you. We hope you enjoy the program.
So welcome again. And so I'm Joey Fishkin. I'm a law professor at UCLA. I am so happy that you all are here. So I'm standing up here as one of the co-organizers of this conference, primarily to thank a bunch of people who made this happen. And then also, secondly, to say something about why we're here, what we're trying to do. I want to thank Georgetown Law for being terrific hosts, especially the Georgetown events team, who worked with us to make this happen: Claire Sanfilippo, Christine Hammer, Jacqueline Diaz, and Catherine Cutler. My co-organizers of this conference, Professors Josh Chaffetz and Bhushan Rogers here at Georgetown, and Willy Forbath, Texas, the American Constitution Society, and in particular, Christopher DeRocher and Doris Zhang, who have done a ton of work to make this conference actually happen. The LPE project, especially Corinne Blalock, who is here, and finally the William and Flora Hewlett Foundation, whose support made this whole thing possible. So I just want to also say something about why we're here today. So Willy Forbath and I spent the past lot of years, I won't say how many, working on this book, The Anti-Oligarchy Constitution, Reconstructing the Economic Foundations of American Democracy. And the book is about a set of arguments, a whole American tradition of arguments stretching back to the founding, that when you have too much economic and political power concentrated in too few hands, this is a constitutional problem. It undermines the Republican form of government that the Constitution promises. So in other words, this is a tradition of Americans making constitutional arguments about political economy. And when we were researching the book, what we realized is that everybody in American politics on all sides used to make a lot of constitutional arguments about political economy. But since the mid-20th century, there's been more of an asymmetry. People on the right have continued to make these arguments, but you don't hear them much on the left. And some of that is because this is a tradition of arguments mostly outside the courts, often challenging the courts. But liberals learned in the mid-20th century to love the courts, to love judicial supremacy, and they did not want to challenge the courts through politics. And meanwhile, economics supplanted political economy, and liberals decided that a lot of questions that used to be political questions instead were technocratic questions for experts. This left progressives in an unfortunate spot when the Supreme Court resumed its project of a century earlier, the project of building a new constitutional set of doctrines that would produce a less democratic, more oligarchic political economy. Anything as big as that shift, as the Supreme Court's lurch to the right, is going to produce many kinds of responses, institutional responses, as well as intellectual responses. And the American Constitution Society has been one important response. For me personally, ACS has been something of an intellectual home since I was a law student, and I'm sure it is also for some of the law students who are here. I saw a bunch of chapter leaders from different chapters around this area are registered for this conference, and some of you are here, also lawyers. And so the ACS is kind of one response. More recently, the law and political economy movement has emerged as another quite different kind of response. Basically, Willy and I just are hugely lucky that while we were working on our book, the LPE movement got underway with scholars and students all around the country rethinking a lot of old assumptions about politics and economics that were well overdue for being rethought. So this conference brings together ACS and LPE, and it does this with an absolutely terrific group of scholars and progressive thinkers and advocates who work on various questions related to constitutional law or political economy or both. Some of the people who you will hear today regularly work on questions of law and political economy, and so we're inviting them to think about the question of how their work relates to constitutional argument. And others of some of the people here today regularly focus on constitutional questions, including questions about interactions between Congress and the executive and the courts, especially fights about constitutional meaning. And we want to invite them to consider what tools Congress and the executive branch have, not just sort of to push back on the courts in general, but in particular to push back against the current court's right-wing vision of constitutional political economy in favor of something more democratic. We want everyone who attends this conference to leave today with hopefully a richer sense of the kinds of arguments that all of us can make out in politics, not just in briefs in a court, about the kind of political economy that we can build in the United States and the potential constitutional foundations and implications of those arguments. I guess my own view of this moment where we are is that ultimately in a democracy, it's not possible for courts to maintain a complete monopoly on interpreting the Constitution. Constitutional arguments are open to everyone, and successful constitutional arguments, the right has conclusively demonstrated at this point, often start outside the courts. So I hope we can use today to think about what kinds of constitutional arguments about political economy we would like to see in the future, even if those arguments are completely at odds with where the court is now and often will require political efforts to challenge the court. And so with that, I am very excited to turn things over to Caroline Frederickson of Georgetown, and before that, for a long time of ACS, to lead our first panel. Thank you.
Well, I couldn't be more thrilled than to be here and to have this opportunity to moderate this panel. As I look out and see so many friends from ACS, from other places, from Georgetown. And it's a terrific thrill to be able to moderate this particular panel in this particular conference, because such great friends here and such great contribution. And just to say, I won't go into my own little story about how I know Joey and Willy, which feels like for many years, but I did want to say that the first book review I ever wrote was of Willy's book, Law and the Shaping of the American Labor Movement. And the most recent book review I've written was of this book. And both of them were fawning, and in a completely deserving way. I absolutely adore these books. And this book has really, I think, done so much to advance the conversation about how we think about our Constitution, our history, and our role as participants in shaping its future. And because we've had such great introductions already, you don't need to hear more from me, because you really want to hear from the panel. And today we are going to open with a short discussion by each of the panelists, and then interact and open it up for questions from the audience. So I hope you're all ready. But with that, I'm going to turn over to Willy to lay the ground for our discussion.
Thank you, Carolyn, and thank you all for coming and traveling far or traveling across the street. Joey and I are grateful, and I'll only re-echo the rest of Joey's thanks. So, what's the topic? The topic of this panel is constitutionalizing political economy a good idea? Joey and I have written a long book explaining why we think the answer is yes. But along the way in that book, we show that for most of US history, the question didn't arise. Political economy simply was the stuff of constitutional law and constitutional politics. Things that today we see as simply matters of economic policy were, for most of our history, the most pressing constitutional issues of the day. Things like the uses and parceling out of the public lands of the West, the tariff, free trade, protectionism, banking and currency, gold versus silver versus greenbacks, antitrust and corporations, labor and employment law, all sides on the major battles about how we organize and govern economic life made constitutional arguments. They made them in court, but above all, they made them in the polity, in election campaigns, and in Congress. These were arguments about what Joey and I call constitutional political economy, and conservatives never stopped making them. But liberals and progressives, as Joey noted, did stop. And as he said, they stopped because they believed in the scientific and technocratic promise of the new discipline of economics. They lost hold of the insight that all these economic questions are at bottom political questions or choices about the distribution of wealth and power and opportunity. They forgot their own traditions of political economy and their own traditions of constitutional arguments in that vein. These traditions, while they were vibrant, right, from the Revolutionary era and early Republic through the New Deal, at least as Joey and I have tried to distill them, right? They changed a lot, but they had three basic precepts. The first two from the very beginning, right? That too much wealth and power in too few hands, right, are a peril for a republic, right? And that a constitution of a republic or a democracy requires a broad dispersal of wealth and power among all the people. A third principle only comes briefly into the mainstream of constitutional politics on the progressive side and into the text with Reconstruction, right? A principle of inclusion that comes to include everybody along lines of race, class, gender, and other lines of division. This is the tradition we reconstruct, and lovingly and at great length, and it's the one that we progressives and liberals have forgotten. By contrast, conservatives never forgot. They famously held on to Lochnerism and constitutional property rights and liberty of contract. They called this the Constitution in exile. And while the mid-20th century Supreme Court had no truck with those ideas, that was no impediment for conservatives, right? Because they had no truck with much of what the mid-20th century court was handing down anyway. And they kept right on making constitutional arguments in the polity. Brown v. Board and the Warren and Burger courts, great civil liberties and civil rights, right? Decisions inspired generations of conservatives to assail the court and its constitutional law as counterfeit and usurpers, right? But these same developments, assailing the court, taking over from liberals and progressives, what had been the liberal and progressive posture toward the Supreme Court, they're not our friends. Their constitution is counterfeit. Their usurpers became the province, right, of conservatism. Right? And liberals and progressives learned to love the court, right? Even now, right, 50, 60 years on, we liberals and progressives have a hard time with the idea of returning to our forebears' insistence that the political branches and the people themselves should have the last word on what our constitutional principles mean. And that's especially poignant because when it comes to political economy, the conservative tradition, the anti-redistributive, anti-regulatory, pro-freedom of enterprise tradition is one courts can take up, as the Roberts-Alito court has amply shown, because it often just involves striking things down. But the progressive tradition I just sketched is one that takes legislative work and administrative work. And the court's role is often simply to stay out of the way in this situation. Bless you. And that may require taking seriously the idea that the legislation at hand, the redistributive legislation that progressives aim to push through Congress, is not just economic policy, but economic policy with a constitutional purpose and constitutional principles driving it. So that now that the Roberts Court is acting like a new Lochner Court, eviscerating measures like Medicaid expansion and campaign finance laws, with student debt forgiveness in the federal court's crosshairs, and a court that's likely to strike down, right? Labor laws, should they emerge, like the one the House passed last year, which protects broad gauge strikes and union organizing. And how are liberals and progressives responding? How are we going to respond, right? For over half a century, our response to such constitutional claims, when they simply came from the Constitution in exile on the fringes, maps onto how so far we seem mostly to be responding now that these arguments are coming from a right-wing majority on the court. Namely, you're wrong. The Constitution doesn't forbid, it permits these forms of redistribution and regulation. We say the Constitution is silent about the distribution of wealth and economic power. But as I've sketched, that has not historically been the way progressives and liberals responded. They didn't say the Constitution only allows, they said the Constitution requires such measures. They said that Congress and others have a constitutional duty to enact and implement measures to build and maintain the kind of political economy, right, that can undergird a democratic republic. Let me wrap up. One high watermark of this tradition was Reconstruction. The framers of those amendments, right, held that Congress had a duty to enact laws that protected the ex-slaves' new civil and political rights, but also a duty to provide land and education, to break up the old slaveholding oligarchy, to provide a social base for the ex-slaves standing as citizens. So the idea was it wasn't enough, as conservatives today imagine, to enact a colorblind principle of racial non-discrimination. What was needed on their account and impelled by their constitutional rights was an upending of the whole Southern plantation oligarchy system, right? And it's that outlook that distills anti-oligarchy, a broad, wide open middle class, and racial inclusion that we say is at the heart of the tradition we've reconstructed. I could go on if we had world enough and time to show how again and again, right, through the New Deal, lawmakers in this ethos and spirit would say, we are not simply doing this because rightly understood the Constitution allows it. Again and again, in ways we've quite forgotten, they said, we're obliged to do these things. This is what the Constitution demands of the government and of the legislature and administration in particular. So what part of what, as Joey said, we hope to rekindle today is what that language and those arguments sound and feel like in this register that I can assure you, one of the richest illustrations of this kind of argumentation, Yochai Benkler pointed us to now years ago in respect of homestead and Galuscious Grow, right? Sort of a great Reconstruction congressman, but a homestead advocate saying, we, right, lawmakers have a duty to enact laws that put land under the feet of landless citizens in order to underpin their citizenship. So this goes on, and the question now is, what would it take to rekindle it? Is it a good idea? And as I've sort of made clear, Joey and I think it is a good idea. I'll note that many of our comrades on the left, including Ryan Durfler, who's sort of one of the most eloquent critics of this idea, is here with us today. And so we'll hear from those who think it may not be such a good idea, but I hope I've told you enough to at least get the conversation started. Thank you very much.
Well, thank you so much, Willy, for a great beginning. And I did want to just note, I am not doing introductions of these panelists because it goes without saying none of them need an introduction. But if you want more, you can use information about, you can find online biographies and so forth, but it would take us an entire day to go through all of their various accomplishments. So we're not going to do that. Instead, we're going to turn over to Michael to respond.
Oh, I thought I was going through, but I'm happy to do it now.
It's
Fine. Yep. Thank you. Can you hear me okay? Yep. Well, thanks for inviting me to take part in this exciting and I hope significant conference. And thanks for Joey and Willy for writing this provocative book, which we could talk about for a long time. Now, I'm neither a lawyer nor a serious student of constitutional law and history. I think I was talking to EJ before. I think we're the only two non-lawyers on the panels today. So, so what I'm going to say in my allotted 10 minutes or so might come off as either ignorant or obvious to those who know con law better than I do. But I do want to raise a question that came from reading their book and also about the overall premise of the conference. And I think Willy just stated it, very well. What will it take to bring this perspective back to American law and American politics? And the question I want to raise is, how have Americans on the broad left, for whom we now use the spongy term progressive, participated in changing how the Constitution is interpreted and was interpreted to advance a more egalitarian and democratic economy, one that can get us closer to a true equality of opportunity, a phrase they use a lot in their book. In other words, what will it take to rekindle this tradition, as Willy mentioned at the end of his remarks. Interesting review of their book in the journal Democracy. Mark Graber, is Mark here? I think so. Mark argued that only Congress can employ, quote, its constitutionally mandated duties to create a democratic political economy when powerful progressive parties gain control of the national government. And that control only happens, I would argue, when social movements exist that are strong enough and follow a shrewd enough strategy, both to put pressure on elected officials and work with them to advance their legislative desires. Only in those circumstances can elected officials win the popular support to appoint judges, friendly to their point of view, or able to make it difficult for conservative judges to oppose their initiatives on constitutional grounds. Progressives have been able to use the Constitution to create a more egalitarian and democratic polity only in certain circumstances. And I want to talk about three of them, and Willy touched on a couple of them, all of them actually already. I want to revisit them in a somewhat different way. Only 3 times in US history has one political party been dominant in American politics that was led by progressives, liberals, leftists at times, who initiated legislation to further economic opportunity and justice. And this was always, all 3 instances, in an environment shaped by social movements on the left. The first was Reconstruction. The 1864 election, the Democratic Party campaigned on the slogan, "The Constitution as it is, the Union as it was," to which one racist Democrat from Ohio added, "and N-words where they are." Fortunately, Lincoln won that election. And after his assassination, Republicans in Congress, led by former abolitionists, the radical Republicans, defeated his successor's plan to let the South back into the Union with no changes, save the abolition of slavery. And then Congress passed the 14th and 15th Amendments and sent them on to the states for ratification. But the movement for racial justice shrank pretty rapidly as Reconstruction came under attack and became unpopular, and federal courts turned against anti-racist legislation that was aimed to build on those amendments. When Congress enacted the 1875 Civil Rights Act in a lame duck session, it was in the wake of Democrats taking control of the House for the first time since before the Civil War. 8 years later, when the Wake Court, with a majority of Republican appointees, struck that law down, it demonstrated that without a powerful and enduring anti-racist movement, the deeply ingrained beliefs and practices of social and legal inequality would endure, whatever the constitutional arguments. Fast forward to the New Deal, the second time when progressives, had a leg up on their opponents politically and constitutionally. As we know, the court in 1937 in Jones v. Laughlin, in effect, reversed its ruling in the Schechter case, at least in terms of labor. Schechter case ruling NRA unconstitutional together with Section 7A, which protected union organizers. But in Jones v. Laughlin, of course, they upheld by one vote the National Labor Relations Act, which helped instill the guiding legislation in labor law today. Now, I'm sure the creative arguments that Senator Robert Wagner and his team of attorneys made about how to interpret the Commerce Clause has something to do with persuading Chief Justice Hughes to change his mind and write the majority opinion. And there's a wonderful chapter, by the way, on this in the anti-oligarchic Constitution. But what if FDR had not won a landslide in 1936? What if union membership were not surging with strikers still sitting down inside the auto plants in Flint, Michigan, at the very time when the opinion came down from the court in February of 1937? Hughes himself argued, and this is a quote from their book, that the economic impact of a strike at Jones and Laughlin, quote, would be immediate and might be catastrophic. Now contrast this, a victory for economic opportunity, with labor's failure in the previous era, the Gompers era, to ward off prosecutions under antitrust legislation and efforts to uphold laws on maximum hours in the Lockman case. Gompers himself was quite learned about constitutional interpretation, much more than John O. Lewis was, or any of the leaders of labor in the 1930s. And he argued his case often with people on the right. But he lost, in large part, I think, because the FFL was not large enough, not strong enough to press politicians or convince judges to agree with their arguments. At the time, the Steelworkers Union, which was, of course, the union that was organizing workers at Jones and Laughlin back in later in the 1930s, was much too weak in the Gompers era to win recognition at hardly any steel plants at the time. Finally, there's the example of how the Warren Court broke the power of states' rights in the 50s and 60s and early 70s. Then the Burger Court in the early 70s. One can't explain the rulings, I think, from Brown v. Board to Baker v. Carr to Loving v. Virginia without the gradual transformation of white public opinion about race, beginning during World War II and continuing the growth of the Black freedom movement over the next 2 decades. If liberal Republicans like Earl Warren had not supported the use of the 14th Amendment to strike down legalized racism, the court would have been far more divided on these and other landmark cases of that era. Now, don't get me wrong, I'm not arguing that judges just follow the election returns. Sound and creative constitutional arguments obviously must be made to win the day, but how those arguments emerge and triumph depends largely on the composition and relative power of social and political forces. So finally, what is the place of constitutional argument in our politics today? Can we engage ordinary people with those arguments? Or is constitutional political economy just a matter for academics, politicians, and attorneys to discuss among themselves in forums like this one? Alas, for me, the answer to that question, at least right now, is a qualified no. Few Americans outside the ranks of law schools, offices, and courts know much about the Constitution. I teach a class on voting in elections at Georgetown to very smart, pretty well-informed undergraduates. And every time I teach it, I get the question, why the hell can't we abolish the Senate? Or at least elect senators by population? Wouldn't that be reasonable? Clearly, no one ever told them about that final clause in Article 5. When they read it, they say, oh, Conservatives, of course, built a large and influential movement on opposition to Roe v. Wade, and the civil rights movement did the same in part by condemning Plessy. But it'll be far more difficult, I think, for progressives to accomplish a similar breakthrough in the cause of economic opportunity, with a far-reaching and easily understood decision to oppose. Not surprisingly, the opposition to Roe v. Wade, the opposition to Plessy, of course, there was a positive side to that in both cases, but they found a important ruling that they could build a movement to oppose. So what's going to be the decision by the Roberts Court, which we're going to build that movement on? I don't know what it is yet, but I think there probably will have to be one. So my point then is really quite simple. To change how the courts interpret the Constitution, we will first have to change the minds of enough Americans who can mobilize to pressure the courts to change. Thank you.
Well, Michael, I did want to say that I think probably even a lot of lawyers don't know about the final clause of Article 5. They just take it on a given that it's in the Constitution, and they don't know that you can't actually amend that part of the Constitution. It is kind of shocking to find out. So with that, I think, Bertrall, it would be great for you to pick up on this theme of popular movements and how it affects our constitutional understandings.
Thanks, Caroline, and thanks for having me here. Thank you, Joey and Willy, for writing this book, and thank you, more importantly, for continuing in the project that this book is motivated by. I want to start by my account of the Constitution. My account of the Constitution, as originally formulated, is that it's an oligarchic, anti-democratic document. And the reason why I say that is because it arose out of a conservative reaction to what was going on in the 1780s. And what was going on in the 1780s was a movement and a push for redistribution that was made by the many poor Americans who found themselves in debt after the American Revolutionary War. And that movement led to such rebellions as happened in Massachusetts, called the Shays Rebellion. It also led to pushes by those who were indebted folks to their government to engage in different types of policies, such as paper money policies that would diminish the value of credit and reduce the cost of debt. It was a movement to create a more level playing field for those who were, in a sense, left out of the economic opportunities that were set forth after the revolution. And I think that once we recognize that part of the project that the court is engaged in is one of reconstructing that conservative, oligarchic, anti-democratic constitution. And if we're going to have a step forward, we need to recognize that we need to recognize that reality and try to shift the focus towards what I think was a truly anti-oligarchic democratic moment, which was the Reconstruction era. That was a moment after the Civil War, of course, in which there was a program to produce and advance the cause of racial justice after many centuries of slavery in this country. But it was not only a racial justice project, it was an economic justice project as well. And that racial justice and economic justice project had a constituency. That constituency were those African Americans who were formerly enslaved that we know about, but it's also a constituency of white Americans in the South who were seeking opportunity as well, many of whom were poor, and also many of them who didn't live in the South as well. I think that once we recognize this new framing moment and sort of focus on this constitutional moment as being the constitutional moment that is entitled to our attention, then we can start to push this idea of an anti-oligarchic constitution in a way that is consistent with the historical development of our Constitution. Now, what we learned in terms of the pushback against this anti-oligarchic original Constitution is that the movement in the Reconstruction era was an important part of it, but what occurred before was also important. And these movements occurred in the states, where there were movements by the people to democratize their state governments, democratize their elections, expand the electorate in ways that would produce opportunities for people to make claims on economic justice. And that was the genesis and the foundation for the reconstruction of Republican government. Republican government as not simply a means by which the wealthy and property elite would control power, but a means by which the economic downtrodden would also have a say and a voice in our development of policies and laws. Now, once we recognize sort of the importance of constituencies, we can start to fast forward to what made the New Deal effective. The New Deal was effective because of what occurred in terms of economic collapse after the stock market collapse and the economic pain that many Americans were suffering through at the time. What that resulted in was a natural constituency for a movement for a progressive political economy. Many Americans were poor, many Americans were suffering, many Americans were making demands on their legislators, both in the federal government and the state government, to provide some form of relief. And that relief came in the form of quite progressive political economy policies in the New Deal era, Social Security Administration perhaps being the key policy, but also a host of programs that were designed to get Americans back to work, produce economic opportunity, and to advance this redistributive idea of government role. Now, I don't want to sort of glorify this moment too much because the New Deal moment was also a racially discriminatory movement, as many African Americans were left out of this project of economic opportunity by programs that were designed principally in many places to advance the opportunity of those downtrodden white folks. But nonetheless, it was an important moment in the sense of rethinking the role of government, rethinking government as a means and an institution for redistribution. Now, we saw the remnants of that play forth in the war on poverty. The remnants of that brought about by the fact that many of these New Deal constituents were still alive and around and still believed in this role of government as an interventionist institution to advance this redistributive political economy, led to the war on poverty that involved the establishment and the passage of laws such as Medicare and other programs that were designed again to put the government in the role of redistributing resources from the wealthy to the less well off. But the problem with this particular program was that it didn't build this constituency for it. The war on poverty was motivated, the story is told, by John F. Kennedy's trip to Appalachia and seeing the other America, seeing the poverty that existed around us, and that moral sense that we need to do something about it. And then there's Lyndon Baines Johnson, who grew up in West Texas, not particularly well off, and was able to empathize with those who were also downtrodden. Those motivations led to the passage of laws at a moment in which we still had this kind of idealistic notion of the role of government. And there were attempts to build a constituency so that it would be sustainable. There was the community action programs that were created in the war on poverty that was designed to allow members of the community to engage in anti-poverty projects and create economic opportunities in their communities. The idea being that these folks who are working on anti-poverty measures would be the future progenitors and supporters of future anti-poverty redistributive measures. And there's also Martin Luther King's Poor People movement, this Poor People movement that he advanced and pushed towards the end of his life. This was a critical, could have been a critical mobilization tool to create a sustainable redistributive political economy notion of the role of government. Now, ultimately, these movements failed for a variety of reasons I won't go into now. But what we were left with was a conservative backlash against redistributive political economy. And that conservative backlash not only involved legislators in a neoliberal project that was anti-redistributive, but also in constructing a court that would not recognize any sort of economic claims. And I think that one of the things that thinking about going forward is how do we sort of build that movement? I think that the project of constitutionalizing or thinking about these things in constitutional terms can be an important motivating tool, but I don't think that's the whole game. I think that the mobilization push is going to be critical. Bringing these elite notions of political economy down to the people is going to be a critical part of the project. It has to be a critical part of the project. And one of the things that we can learn from the conservative counterparts is that they have done some of that work. It's not simply Federalist Society talking at the elite level, it's connecting with the Tea Party folks on the ground, something I talked to about with someone before coming up here. And that mobilization of that grassroots movement that is working against the interests of many of those that are part of the movement has been quite successful in halting a progressive political economy movement. So how do we rethink things? How do we think about things going forward? Well, I think there are two major obstacles right now to any sort of progressive political economy from a mobilization perspective. The first obstacle has to do with the racial divisions that exist, especially when it comes to economic justice. One of the things that has been so successful in maintaining oligarchies worldwide is dividing those lower income and working class individuals according to some on some basis. And in America, that basis is race. And those racial divisions that arise from the sense that the notion that identity politics and advancing the causes of racial justice are against the interests of those who are lower income white folks, in the sense that those folks are being left behind and we need to make America great again and nostalgizing about the past of white glory. That's part of sort of the racial divisions that have been constructed that has acted as a major obstacle to mobilization around redistributive political economy. The second obstacle is that we just have a complete disconnect between the elite and the poor, and the parties are perhaps the best agents of social movements right now. And what we're seeing is that they are not making those connections with those who are least amongst us. What we see consistently and persistently is a gap in terms of who political parties contact, who they engage during political campaigns, and who are part of a process of democratization. It's not a democracy for all of us. It seems to be a democracy for the middle class and the wealthy. And to the extent that the poor and less well off are left behind, they're going to be ripe for recruitment by anti-democratic, anti-redistributive forces. And so to think about sort of constitutionalizing political economy, we need to think about how do we engage and bring those who are least amongst us into this project. Thanks.
Well, I want to turn to Sabeel next, because I think Bertrall brought up a lot of themes that Sabeel is going to touch on in terms of movements and institutions and their interactions.
Yeah, great. Thanks, Grant. And thanks so much. It's great to be a part of this conversation and seeing lots of old and new friends here. And I should say it's a particular treat to comment on Willy and Joey's book, because I feel like I've been learning from the book in the whole course of its kind of creation. Right? I think very early on, one of the first panels I did when I started teaching was with Willy, when this book was a germ. And so I'm just kind of pulling on things that I've been thinking about in thanks to them over these last couple of years. I should also say a disclaimer that I'm here in my academic and personal capacity, and of course not speaking on behalf of OMB, where I currently work. So let me pick up on a couple of threads that really everyone has laid out so wonderfully. First, a little bit about what the kind of moral force of a constitutional or kind of bringing the concept of constitutional in might do. Second, a little bit more about what the theory of change is here that we could imagine when we knit together the comments about movements and institution building and policy, and then a little bit about kind of how ideas operate in the world. So first on what we mean by constitutionalism. So this may be more of a stretch than Willy and Joy would want to make necessarily with the concept, but in some ways, I feel like the force of the argument doesn't necessarily depend that much on the paper constitution at all. but it's really about the highest moral stakes of the conversation that we're trying to have about literally who and what constitutes this country. Who is a part of the polity? What are they owed? Are we owed as being part of that polity? And then what are the institutions we are literally constructing, building, creating, or deconstructing to make possible that idea of inclusion and membership? And I say that because in part channeling what Bertrall was saying, right? The institutions we have inherited aren't always animated by that ethos, but the moral force of the movements and reform efforts of the past that have created different institutions over time, Reconstruction, the New Deal, the second Reconstruction of the Civil Rights era, really are about an attempt to constitute a different democracy. So I think that's helpful to sort of see, excuse me, the questions about, how to use the arguments in court, say, as a subset, I think, of a broader set of questions that the book is prompting us to think about how do we make real those moral aspirations for an inclusive democracy. So then let me say a little bit about institutional change. And I want to continue the theme of some historic examples by double clicking on a couple of the ones that have already been named. So one is, if we think back to sort of the early New Deal and even before in the progressive era, one thing I've always been fascinated by is the kind of late 19th century battles over public utility, monopoly, and sort of the early rise of the administrative state. And lots of amazing folks in this room and in our larger ecosystem have been writing about this. But I think it's notable that when you have this sort of heyday of, like, let's say, fair political economy, there are all these early battles at the state and local level, as you're saying, Bertrall, and driven by social movements, to your point, Michael, that are really about wresting back control over those basic necessities on which everyone depends. So you see all these fights over gas works, electric utilities, water, and it's kind of nuts and bolts stuff, but it's actually those instances where individuals and communities are experiencing that reality of domination, of arbitrary power, that they now depend on these services that are run by private companies that are not accountable to the public and that are not obligated to provide those services freely and openly to all who need them. And out of that emerges then a bunch of new policies and a bunch of new institutions. It's why we have public utilities at the state and local level. It's how the early New Dealers kind of cut their teeth literally as kind of early stage bureaucrats in the state level, from which they then learn and then help inform what comes later in the New Deal. So I think it's an interesting story about localism, experimentation, movements, and the interaction between ideas and then institutions that emerge. A couple of other quick ones. Fast forward then to the civil rights era. Another example that I love is thinking about the early days of the implementation of Medicare. So after the Civil Rights Act was passed and then Medicare was put in place, it was not obvious that it would be implemented in a racially non-discriminatory way. That was a fight. And it was a fight that played out in part through this interaction between movements and the administrative state. So you had the NAACP, different sort of leading civil rights figures and organizations pushing for a particular way to implement this policy. And you also had then a parallel fight within what was then the Department of Health, Education, and Welfare to try to think through what that would mean. The end result of it was a decision to actually take on board Title VI of the Civil Rights Act and incorporate it into the policies of the department to say that it is actually in fact part of our job as HEW to enforce civil rights through the funding streams and the way we monitor hospitals to make sure that they are not operating in a racially discriminatory way. But that was a choice that had to be made, and it was contested. And it was contested under conditions of pressure from social movements. So I think it's another kind of crystallization of what we're talking about on the panel. To me, the payoff here then is that when we're thinking about how ideas like those are traced through Willy and Joey's book become real, it's really about this interaction in my mind between the ideas themselves, like what is the moral goal we're trying to achieve, the organizations, movement organizations, civil society organizations that incubate, channel, advocate for those ideas, and then the institutions in which those ideas become established and instantiated. You need all three of those things for the end result to be felt in the world in the way that we want. You remove one of those three and it doesn't quite gel or doesn't quite stick. And I think that's a lot of what when we think about theory of change, it's a lot of what we're struggling with here. So let me say then a a couple of last quick words, because I know we want to get to the discussion and get to EJ's comments about what this means in context of the administrative state. So we now have thanks to these previous efforts, we have a bureaucracy that exists that executes a lot of these functions. And I think it's worth thinking through the constitutional, political, economic stakes of debates over administrative policy. So when we have privatization of state and local functions, for example, or the rise of administrative burdens that might make it harder for individuals to access critical services, safety net programs. Or if we think in say, the criminal law or immigration context, the over-enforcement or arbitrary enforcement, unchecked power of agencies. These are all instances in which the operation of it, the day-to-day operation of bureaucratic institutions actually has, I think, this higher constitutional, political, economic stakes. Conversely, if we're trying to make that the inclusionary democratic ideal real, I think that means we need to think about what are the new institutions that need to be created, right? DOJ comes out of Reconstruction in a lot of ways. Out of the 2008 crisis came a bunch of other new administrative institutions. So what is the sort of state building, institution building project to which this enterprise corresponds? And then by way of closing, I'll just say I think these conversations are exactly what I think we want to see more of, right? We're knitting together sort of communities of practitioners across academia, policy, law, organizing, and so appreciate the organizing that has happened thanks to this book that we all get to be in this conversation.
Okay, well, thanks, Sabeel, for some great. You made me think about how the Department of Homeland Security came about after 9/11. So sort of what can happen in the other direction. So EJ, there's a lot to talk about here. And I know you have a lot of comments about the book and how we should respond to it.
Well, thank you so much. I just want to begin by saluting the American Constitution Society and particularly the students who are part of it here, and Carolyn for all her work on it. Never has its work been more important. So thank you for being there and doing that work. Secondly, I want to acknowledge a very old friendship, which is with the gentleman to my right, only in terms of the location on this platform. I'm not making a political comment there. I always tell our kids that one of the few advantages of growing old is to have old friends. And Willy's been teaching me stuff for 50 years, so it's a real blessing. And I really wish I didn't have to say this. This book is extraordinarily important and relevant to the crisis of our time. I wish I didn't have to say it because I wish we didn't have the crisis that it addresses. But I have to say that I was deeply excited by this book, not just because Willy is a co-author, but because I think it answers some real problems we have. When I was looking at the form we had to sign when you come in here, ACS is a 501c3. And there is a little sentence in here that says, please refrain from expressing any views that could reasonably be interpreted as endorsing any candidate or party in an election. So I would like to shout out Republican appointed judges such as Stevens and Souter and Brennan and Warren. And I shout those out to underscore how radical the situation we confront is, because these Republican judges did not try to push our nation in the direction that we are being pushed in now. They did not try to undercut all that New Deal era, post-New Deal jurisprudence accomplished. They did not try to bring us back to a so-called constitution in exile. And so I was excited by this book because I think that those of us who believe in a democracy. Oh, by the way, I also want to shout out, I think he left for the moment, but Ganesh Rahman was in the audience. And I think his book, The Crisis of the Middle Class Constitution, is very much a brotherly or sisterly book to this one. So I'd like to think that we're here at the beginning of a movement. Remember when the Federalist Society was founded, people always go back, what was the early history of that? Maybe this meeting will be the early history of what happens. This gathering will be the early history of what happens next. But think about what we are confronting now. The Dobbs decision obviously created a small d democratic discussion around constitutional decisions like we have never seen before. It has not been the case for the entire period since the Warren Court that when voters said they were concerned about the courts or concerned about court decisions, they were not voting for the more conservative party. They were voting for the more progressive party. But this is only one of a long list of decisions the courts have made that I think can fairly be seen as de-democratizing or anti-democratizing decisions on voting rights, on gerrymandering, on environmental regulation, on labor law, on finance, firearms regulation, and of course, quite directly to the title of this book, on campaign finance regulation. And that in many of these decisions, conservative justices have overturned understandings that were 30 to a century old. The campaign finance reform is a good example of a set of understandings of what government could do to ensure a more democratic republic that go back to the progressive era. So that's what they're confronting now. I am not up here as a constitutional lawyer or a historian, but I do write a lot of columns. I suppose my conservative friends would say I pretend to be a constitutional lawyer, or at least a lawyer in many of my columns, because this is an issue that I have been deeply concerned about for a very long time, the rise of conservative judicial activism. Notice that phrase, by the way, judicial activism. Until, about 5 years ago, that was the attack that conservatives leveled against liberals. We are against judicial activism. Suddenly, I'm hearing fewer arguments about judicial activism from the right and more fundamental arguments about how we have to undo a whole series of court decisions from the past. Why I think this book is so important is precisely because of what Mike Kazin said about the importance of social movements, which is, I think it is deeply important now to link small d democratic politics to our arguments over the judiciary. It is, at the risk of paraphrasing Richard Nixon, more important now than ever to do what Joey and Willy prescribe in this book. And as somebody who tries to make arguments about what is flawed about this new round of conservative jurisprudence, I think their argument that constitutionalism has been part of the American political argument from the beginning of the Republic is deeply important. Just a couple of exciting moments in the book early on when I was reading it, Americans making arguments in what they call the democracy of opportunity tradition through most of American history did not view their constitutional arguments, or for that matter, those of their opponents, as outside constraints on democratic politics. Instead, they were the substance of democratic constitutional politics. They saw the political branches were crucial fora in which constitutional conflicts and deliberations unfolded. Far from being conversation stoppers, constitutional claims were central to great national political debates. That's where we are now. And if the Supreme Court is going to set itself up as a body which can stop democratization, can stop the decisions made by the democratic branches with no accountability, we are giving it power that in our history we never did. And Willy is absolutely right that liberals got themselves out of the argument because they trusted the courts for a long time, were happy with the results, and sort of lost track of the tradition that Joey and Willy try to bring back. 2 points I'll make in closing. First, I am very happy that Bertrall Ross raised the issues he did. Let's be honest, there's been an argument among progressives going way back about whether the Constitution itself is primarily democratizing or anti-democratizing. I think that I appreciate the distinction you made between the Constitution as amended in the second founding versus the Constitution that we had in the first place. And I think the importance of your point is underscored by what conservative justices have been appealing to of late. Talk about not appealing to the language of the Constitution. They have started using the terms quite promiscuously, history and tradition in making decisions. And somehow the history they appeal to and the tradition they appeal to somehow goes all the way back to before the Civil War amendments. It somehow kind of wipes them out or blurs them. And I think that's very important. But one of the questions I would love Willy to confront is about the Constitution itself. Sandy Levinson, great lawyer at UT with Willy, wrote a book called Our Undemocratic Constitution. So I want you to engage that. I think the Constitution, as, if you will, corrected by the Civil War amendments, is a more democratic document, but I think it's still a fundamental debate. Last point that I want to make, I said I'm in the middle of these arguments and about the court. And there are sort of two broad arguments liberals have relied on. One is the living Constitution that worked for a long time. And there have been some great cases made for the living Constitution. David Strauss at the University of Chicago Law School wrote a great book on the living Constitution. But I've always thought, as somebody in the field of making arguments, that it didn't stand up very strongly against originalism. Now, it's delightful to see originalism come in under scrutiny in a way I don't think it's come under for a long time. And somehow about 80% of the time it leads to the results that you'd think the people using that term would reach, whether they had the originalist theory or not. But I don't think the living Constitution in the sphere of public opinion ever fully answered the originalist arguments, because it made it easy for them to say, you guys are just making stuff up and calling it the living Constitution. I think the view that Joey and Willy advanced actually is a stronger, and Ganesh, as I mentioned earlier, is a stronger argument that this Constitution is designed to create a democratic republic, and a democratic republic has certain requirements when it comes to the kind of society that undergird it. And then the other is the New Deal settlement, which we were quite happy with in terms of results, but I don't think had the strong undergirding of a theory of democracy and what it requires. When many of you know that one of the pushbacks always against progressives who talk about democracy is the old line, I think it may go back to the John Birch Society, but it may predate that, we're a republic, not a democracy, they say. Actually, our answer to that is we are a democratic republic, or at least aspire to be one. And a democratic republic does require a sufficiently democratic economy to support it. The Constitution begins with the words, we the people. The preamble imagines an active government that is responsive to the interests of the people, including the general welfare. I love to tell conservative friends the word welfare is right there in the first paragraph of the Constitution of the United States, including the general welfare. I think Joey and Willy have outlined an argument that we need to build the social movements that Michael talked about, to defend the rulings, to defend the role of an administrative state designed to secure the public interest, and to fight the injustices, historic injustices that we are still trying to overcome, that Bertrall talked about. So I thank you, and I hope you begin a movement with this book.
Thanks. EJ, you gave us a lot to think about, and I just wanted to make a couple points first about history and tradition. I think it actually goes back to the 13th century.
Yes, some of it.
Let's not forget.
There were
Just-
some witches in there. I
Yes.
think.
Yes, or at least, yes, anyway. I would also say that what your fellow columnist at the Washington Post, George Will, gave a fierce call out to judicial activism just a few years ago. I think as soon as he saw where the
Sure,
court
can I
was
say
going.
he was intellectually honest in saying, no, we should not be as conservatives against
Right,
judicial activists. And
But he was the first one I saw that actually was was honest like that, who actually said, hey, let's be activists because let's get what we want finally. And the other thing that sort of lead into a general question, and maybe we'll start with Willy, because I think EJ kind of threw out a challenge for you to respond to this idea that, it's not an anti-oligarchy constitution. It's an oligarchy constitution. Let's be honest, right? Who founded this country? But in that sense, I wanted to go back to the judges you mentioned, the Republican appointed judges, and just to say, at best, they were certainly open to the idea of regulation of the economy, but they wouldn't claim there was a duty either by Congress, that there was an anti-oligarchy impetus for legislative action. So is there or is there not an anti-oligarchic push in our Constitution? And how do you challenge, Willy, the idea that actually it's really truly an oligarchic constitution?
Okay, first, thank you to one and all. And then let me plunge into, let the wild rumpus begin. So the way we take on Bertrall's point is this. Bertrall is absolutely right. The most sort of radical and democratic elements in the constitutional politics of the Revolutionary era were at the state level. And the gentlemen who gathered in Philadelphia gathered in significant part for many reasons, but one of them was surely, as they put it, to subdue the states because they were too democratical, as they put it. And the story we tell, which draws on a wealth of constitutional historical work all around us, is that impetus at first found expression as resistance to the Constitution when it was brought forward for ratification. The anti-federalists, those who opposed the new Constitution, were the anti-oligarchs in their discourse and their framing of the question. And what happened almost immediately when the handiwork was ratified, the arguments that were the most robustly democratic with a small d and anti-oligarch became part of our constitutional politics. The tradition that we're reconstructing is one that takes on board that moment when the most sort of oligarchic aspects of the Constitution, and bear in mind that what Hamilton and others had in mind would have been vastly more oligarchical had it not been the case that the gentlemen of Philadelphia said, no, the people won't accept that. We won't enact what we want if we go full bore oligarchic in the ways we want, or as they saw it, a more elite republic, a republic in which patricians ruled. And they had many provisions, and Hamilton was a past master at conjuring up a truly oligarchic constitution. They tempered it, but nevertheless, it was a document that could have been used to build a very highly centralized, very elite republic. But what emerged swiftly were movements to grab hold of the anti-oligarchic aspects of the politics of the revolution and bring them into our constitutional politics and create our first mass party. So the Democratic Party was created to save the republic from the oligarchic projects as they saw it. And obviously we progressives have good things to say about Hamilton even before Lin-Manuel, but the point was that anti-oligarchy entered our constitutional tradition and history, as a rival interpretation of the Constitution itself, one that left more space for a more decentralized political economy, because that was, right, willy-nilly part of our constitutional politics and part of what was being argued about. So yes, we can take on board Bertrall's points about the ways in which the Constitution was framed to subdue the most democratic aspects of our revolutionary politics. But we would push back any proposition that it was so rigidly, right, confined that it didn't, right, immediately open up to interpretations that were small d more democratic than the gentleman in Philadelphia would have preferred. And some of those gentlemen, of course, became leaders of a democratical opposition, as they put it. That was still a bunch of slaveholders, which is why the second founding plays the role it does in our book. The only other thing I'll say, and then I'll sort of return it the floor to Carolyn and you all, is that, make no mistake, Joey and I are not chiefly about making arguments to the court. And this is partly in response to Mike's points. We're not waiting for the day when the court will welcome the arguments on offer here. We see these arguments as ones not just to make in Congress, but ones to make in service of attacking the court, taking power away from the court, so that we see a long tradition of let's abolish the Senate, let's reform the Senate, let's take judicial review away from the court, let's take bits of judicial review away from the court, let's pack the court, let's shrink the court. What struck Joey and me is that this kind of hardball politics against the court's power and its doctrines was again and again, no matter how radical the claims, framed as let's bring back the most radical but robust elements of our constitutional tradition, even if that requires taking power away from the court or changing the Senate. So that we're saying this tradition is, right, capacious enough and rich enough and substantive enough to animate the most deep structural reforms our polity can require. But if we just say, let's ignore the court, let's ignore the Constitution, you leave on the table, right, arguments that might bring on board more of the American public for deep structural changes that otherwise seem scary and, right, motivated by simple tit for tat politics.
Right. Well, thank you. I'm sadly very conscious of the fact that I think we only have half an hour left. So I want to ask one sort of general question to the panel and then engage. I'm sure there are a lot of questions out there. So, if we're looking ahead and we as progressives or liberals or whatever is the term that we want to use these days, want to actually make arguments about a progressive or about a constitutional political economy. And what are the areas that we should focus on? I mean, should we focus on healthcare, on education, or maybe take on competition itself? The whole idea of oligarchy and monopoly directly. What are the issues around which we should engage, and how should we do that?
So I guess I'll start, and since I'm on the end, okay, move that way. Can I say just a couple things in response to Willy's point? Just like a small. I'll keep it short.
You have the microphone.
Yeah, keep it short. Sorry, I won't say much. I completely agree with much of what Willy has said, and what this really reminds me of is the stakes of the court's interpretive approach. And their interpretive approach is not as historically contextualized as Willy and Joey's book is. Instead, it is more focused on particular documents that perhaps advance the most oligarchic, anti-democratic aspects of our Constitution. If you focus on the Constitutional Convention, yes, there was kind of this pushback and idea that, okay, we can't go too far, but there are very oligarchic, anti-democratic views expressed in that convention that could be drawn from in the court's jurisprudence to advance a very conservative, regressive notion of constitutional republic, right? And then there's the Federalist Papers, right? And the Federalist Papers, you can see them walking some of those things that they say in the convention back. I think that the Federalist Papers is the biggest sort of gaslighting instrument that we have out there. But at the same time, there are still left in that Federalist Papers, these oligarchic, anti-democratic notions. And what's forgotten are those anti-Federalist Papers. What's forgotten are the movements that occurred in the states after the passage or the ratification of the Constitution that were much more progressive minded in terms of democratization and anti-oligarchy. And the key is, and I think there's an interesting opening that's presented by this new tradition and history analysis that the court's engaged in. Yes, they've engaged in very sort of selective history, drawing from 13th century. They only cite white men in their treatises. They only cite democratic institutions that were all white men, sure. But if we can get the court using the tradition of history analysis to focus on other histories, the histories of other people, the histories of all Americans, for example, the histories of women when you're thinking about abortion rights, the history of LGBTQ people in this country when you think about LGBTQ rights, and incorporating that into its analysis as to what should be protected as fundamental. I think that that could be an opening for a new different types of constitutional interpretive theory that fits in within this historical account, but accounts for not the dominant white man majoritarian history, or white man, sorry, not even majority, minority history, but the history of all Americans. And I think that that's something we need to think about. In terms of responding directly to Caroline's question, one of the histories and one of the moments, one of the things that we need to draw from history is the centrality of education to Republican government. This was something that was expressed repeatedly in state constitutional conventions that were put forth in the early parts of the 19th century through the latter parts of the 19th century into the 20th century. We need an educated populace to operate a Republican government. There's a recognition that if we don't have an educated populace, Republican government cannot survive. And they fear the same things I fear right now, that if we don't have educated individuals, they're likely to be misled or corrupted or recruited by authoritarian, anti-Republican, anti-democratic individuals, movements, forces. And so we should bring that into our constitutional notion, right? Fit in within this Republican government. And we talk about what claims can we make outside the court. Well, we can make claims on those parts of the Constitution that the court has neglected or rejected as being within its purview. Republican form of government, Ninth Amendment, retention of rights, privileges and immunities. Incorporate that into our sort of claims on what the Constitution demands and requires, and build within it these notions of protecting rights to education and extending education so that we could truly have a Republican form of government.
Thank you. Sabeel.
Yeah, great. So I probably won't say much about live policy issues going forward, but I do want to speak to your question, Caroline, and this conversation with a different angle, which is, I think, of course, I love the emphasis on movements. One thing I would offer, so before my current role, had the privilege of working in the advocacy realm and with a lot of colleagues in the social movement space, and would say like there's movement happening right now. It's not what should the movement be that we create. Like we are living in a time of deep rupture of a lot of both suffering, but also like genuine, amazing organizing, creative thinking, strategizing, and it's happening in a lot of places. So I offer that as I think a friendly amendment, right, to the discussion that sort of, the question isn't so much what ought one focus on, the question is what are the conditions under which the kinds of demands that are already being formulated have force and have durable force. And I think that's true historically too. So, we talked a little bit about the New Deal. I'm always struck by, even as the New Deal itself had its own sort of reaffirmation of the history of racial discrimination, it's also true that forces like the CIO, for example, as one of the few, if not only racially inclusive unions, formed the left flank of the New Deal coalition and played a huge role in making the New Deal what it was, and also setting up the realignment of the parties that then followed, right? And that's a story about organizing and strategy and its interaction with live politics. And I think the point that Bertrall was making about sort of counter organization is also really important. So when you were talking about the war on poverty, Bertrall, I think there's also a story to be told about the ways in which advances under the war on poverty and in community action programs were deliberately undercut, right, by Democratic mayors and in particular cities, and their friends in the governor's mansions and in DC. So it's not happening in a vacuum, but it is happening. And so I think questions like, how do the pieces add up to be more than the sum of the parts, as opposed to like, what do we need to gin up out of thin air?
Great, thank you. And Michael, historical perspective.
Yeah, I should say I'm learning a lot from this panel. Thanks very much to very impressive colleagues here. I should be down there taking notes rather than up here talking, but couple historical notes, and then, what should we do now? Response. I was thinking while, Bertrall was talking about the Constitution, Tom Paine supported the Constitution. Tom Paine was a Federalist. And as I remember, it's been a long time since I read Eric Foner's fine biography of him, but I think he did it because he felt that better to have a central government you can fight with and for and try to change than have all these different semi-independent state governments under the Articles of Confederation, which will inevitably be controlled by the local oligarchs, and also a lot of this discussion about, what good is the Constitution takes me back to the famous, at least famous among, historians like me, argument between William Lloyd Garrison and Frederick Douglass about the Constitution. Famously, Garrison, was burning copies of the Constitution and saying no union with slaveholders, even talking about secession of the North from the Union for a while in the early 1850s, before the Free Soil Party was really getting going, before, of course, the Republican Party got going. And Douglass made this important change from being a Garrisonian to by late 1840s, late 1850s, saying, no, we can use the Constitution. There's various ways. Some of the preamble he was talking about, some of the amendments, took the Commerce Clause. He made some very powerful constitutional arguments that in the end carried the day, talking about, no property in man, that kind of thing, going back again to the Constitutional Convention itself. So, we've had this argument's been around before among progressives, leftists, call them what you will. Well, what part of the Constitution should we fight for? Should we use as a battering ram, to change politics, at least begin to change politics? I wish I knew. I mean, I keep thinking as people were talking, what's our Second Amendment? Obviously the right has used the Second Amendment for quite a while now, to push not just an argument about the right to take your firearms into anywhere you want to take them, but also about the power of the federal government to over people's lives and built pretty powerful movements about those issues, as we know, and of course won the day in the court and in state courts as well. So what's going to be the analogy for us? I don't know what that is. Again, I'm not a constitutional lawyer or for that matter, a political strategist. But I think, as I said in my remarks, I think we have to think about the question of strategy here. It's not going to be enough to boil down, this wonderful book, I think, and say, here, read this, this will tell you as an activist, what you should do. It's a thorny matter. With Douglass, it was easy. Obviously, the issue was trying to stop, this horrific institution of human bondage. But talking about the economy is not as easy as that. It's a more complex question. And so I wish I knew the answer to that, but I'd like to know what our Second Amendment is going to be.
So-
Well, thank you. And I just want to say, it does seem like they've actually also weaponized the First Amendment. So, so EJ, I actually want to, if I can slightly reformulate the question for you, maybe as our major communicator up here on the panel, someone who speaks to the broad public all the time and so eloquently. And you've already talked about originalism, but I wonder if we've already defeated it. I think in the sense of there's no content there, right? There's been plenty of great arguments about why it doesn't hold water. Does this book and these kinds of arguments offer us the positive vision that we need? Should we just move off of contesting originalism all the time and actually have an affirmative vision?
Right, the short answer is yes, and then I'll say no more. But yes, I think and that's why I sort of linked up Ganesh and Joey and Willy together, because I think what you have here is the beginning of a much more fundamental answer to what judicial conservatives could say. just a quick answer to Michael's question. What I think is interesting is the NRA came up with this Second Amendment argument in response to the use of the First Amendment by progressives. And that the use on the broadly liberal in the American sense side of the First Amendment was their response. And I am very fond of the preamble, but we can talk about that another time. But yes, so I do think that an argument that says the Constitution as amended, and again, I really point to the Constitution with a Bill of Rights, with the preamble taken seriously, and with the Civil War amendments, is something that all of us have repaired to at one time or another for protection. And that if you did a word search on the January 6th hearings, I dare say the word Constitution was said as often as, say, the identity of a certain other person, to not to violate this little piece of paper. We repair to the Constitution too, and I don't think this is just sentimental. I think that people with all of those, people view the Constitution in its entirety as something that we can appeal to for rights. That we all take very seriously, but that includes the right to organize, that includes the right to democratic, inclusive, free elections. So to answer your original question, I do think the voting rights area is an extremely important, voting rights gerrymandering is an extremely important place to start in pushing back against what this court is doing. And I think the arguments advanced here are really, I think, allow us correctly to argue that enlargement or efforts to limit the court's authority is not a power grab. It is an effort to stop a power grab. It is a response to a power grab. And that we are witnessing a court that could radically limit the capacity, our capacity as citizens, to respond democratically to their rulings. And so I think it's very important to be very clear of who is grabbing power illegitimately, and then let's take the argument from there.
All right, I'm sure now this is an audience full of lawyers, law professors, law students, and engaged people. I'm sure there are a ton of questions out there, and we only have about 18 minutes. So Barry Lynn.
Yeah, I'm Barry Lynn. I run the Open Markets Institute here in DC. Yeah, I mean, I'm thrilled that you guys are, have written this book, and just wanted to play off of something that Sabeel said, which is that, the movement is very much already underway. This is not the purpose of the book is perhaps not to spark the movement. It's actually, I think, to provide a doorway through which a lot of people can actually understand and join the movement. But just put some ideas out there. I mean, just as to see how far along this already is President Biden last year in his executive order on competition, he spoke about how, we have to get rid of Borkism, neoliberalism, and restore the idea that anti-monopoly is to create democracy and to protect liberty. Senator Warren said the exact same thing in 2016. And I know that because we hosted that speech. Zephyr Teachout said this in 2014 when she was running against Cuomo. And in her book, Corruption in America. My book came out in 2010, Cornered. The Tea Party and Occupy, that was 2010, 2011. So, there's nothing to kindle here. It's like it's already, it's already a flame. And I think just through the lens of anti-monopoly, what we see right now is that we see constitutional debates that are taking place in real time every day on speech, on debate, the future of the press, the distribution of property, the well-being of labor, opportunity, national security. So again, I think, we welcome this book as a doorway that actually through which the movement people and the academics can meet.
Yes.
Hi, I'm Osito Anave. I'm a contributing editor at the New Republic. I guess this is going to be a running theme all day, but I did want to push for more responses on what it means to argue that progressives should couch themselves further within a constitutional tradition at a moment where more and more people are just sort of realizing and understanding that the Constitution as a basic framework is less and less functional by democratic standards. And people are asking, whatever we think about what happened in 1787, will it make sense as a matter of governance to be, structured in accordance with this document 100 years from now? The Constitution of 1787 had a Senate. The post-Reconstruction Constitution has a Senate. As capacious as the progressive constitutional tradition seems, and I think it does seem capacious, I think it's still going to have a Senate. I don't think that there is a constitutional argument you can make that gets rid of that body. So if we think we can do better, and we should do better at some point, how should we think about the role of these kinds of arguments in accordance with the longer term goal of moving towards some other compact or arrangement that would be more equitable in the future? Because the Senate, it's not just a matter of abstract political equality. The power that's afforded to small states obviously has real relevance for questions of political economy. So how do we think about that structural lingering issue and others in the Constitution while also making constitutional arguments for progressive aims at the same time?
Could I give a quick answer and just to see what others want to say? First of all, it's a great question. And I'm sympathetic to the idea of how do we reimagine this document. The Democracy Journal, where I'm on the board, wrote a new constitution. It's got a whole bunch of scholars together to say, if you were to rewrite this document from scratch, how would you do it? And there are changes, particularly the Senate, I think you're right to underscore that, because the document makes it very hard to change. But the reason why I think nonetheless it is useful to have this constitutional argument is because, as you suggested, we've gone through periods in our history of having a constitutional imagination and then losing it, of being willing to think fundamentally about the document and then losing that. So we did have the Civil War amendments. We did have the progressive era amendments. We had some amendments in the 1960s, for example, getting rid of the poll tax. We have, for a variety of reasons, some of which is just a lot of people think no progressive amendments can possibly pass because of the 3/4 rule. We've lost our constitutional imagination. And so I think thinking within a constitutional framework is useful precisely because it prods us to think what is valuable in this tradition and what needs to be changed now.
Can I just say a couple of things that I think that I agree with EJ very much, and to say that we're not very imaginative sometimes. I wish that we could engage the broader progressive movement across this country for understanding why DC statehood is so important. Why aren't we thinking about Article 5, right? So it's also raises the question of whether can you really say something in a constitution that you can't amend this part of the Constitution? That raises its own constitutional questions. But let's say we take that as a given, right? We can't amend the Senate because of Article 5. Why don't we expand the number of states? Why don't we think about that anyway? Why wouldn't we think about certainly Puerto Rico, the territories, DC, creating a few California, South Carolina, California, North California, et cetera. There's certainly ways that we could approach it. In addition to sort of rethinking of how do we reimagine the Constitution more generally, but I find it very troubling that we haven't engaged the broader progressive movement in thinking about, at least let's start with DC. It's an outrage, right?
By the way, if you want a really roaring, raw political fight, try to figure out whether you split California east-west or north-south. But anyway, that's.
Yeah, I always tell conservative friends, say, we shouldn't let DC or Puerto Rico in, you know, in less than a year, Republican Congress from 1889, 1890 created 6 new states, you know, and why is it North Dakota and South Dakota? I mean, made no sense, but
I mean, we celebrate the fact that we have the world's oldest constitution, and I question why we're celebrating that, right? I think it's worth celebrating that we have one of the oldest constitutional republics, but that doesn't necessitate that we maintain the same old constitutional document. But I think that what the value of current constitutional arguments are is to allow us to see what their limits are, how they're limited by the Constitution. So you keep pushing these arguments and putting them out there like Willy and Joey have. And then we come to this point where like, oh, we have a wall here. We've reached a wall. And I think that that will then motivate people to thinking and revive the imagination that EJ and Caroline are talking about with respect to the constitutional framework we have. And so I think it's important to kind of keep putting these out there. And then, oh, we have a Senate that is a wall. We have a life tenured judiciary with justices that will be on the court for 40, 50 years. That's a wall. Maybe it's time to change. And that change may not be through an amendment process because there's a lot of folks that have stakes in what is, right? How do you change a Senate when so many states benefit from the current framework? It may be sort of that new constitutional convention that so many people fear. That new constitutional convention that leads us to kind of say, okay, how do we do things differently? And I think that perhaps we may be getting to that point soon.
Anybody else want to respond, or should we go to another question?
Well, I'm on board with everything that Bertrall and Carolyn and EJ have said, that deep structural changes is part, you know, not as kind of consistent a part of our history as many of us would hope, but nonetheless is. And it's still framed precisely as a project of constitutional imagination, including deep structural change. But you need, particularly from the social movement perspective, you need some normative grounding. Why are we pushing? Why is this wall a fundamental impediment? What's the project here? Or as Sabeel said, who are we and what are the instruments of government we need? All of that is fair game, you know, in constitutional politics, as Joey and I have tried to evoke.
Other questions? Yes, in the back.
Hi there, y'all. Thank you for this panel. My name is Sumit. I'm the president of ACS at UVA. And Professor Kazin and Ross made comments respectively about state oligarchs and the centrality of education, right, in sustaining the republic. And that got me thinking about state executives, right, and governors like Youngkin down in Virginia, who are pushing projects, right, like critical race theory and pushing against critical race theory to the point where now he's proposed history standards for a curriculum that has no mention of Martin Luther King or LGBTQ folks, right? So these are really concerning developments, and it seems clear that there's political remedies to stuff like this. But again, as this sense of state oligarchy congeals, there's a need, I think, for legal remedies. Do y'all know of any legal remedies or how we might think about legal remedies in these politically dominated spaces that are congealing this oligarchy?
Why don't you take the case? You're down at UVA.
Yeah, you've got.
Miriam Siefter has done some work on state democracies and how they're evolving in sometimes democratic and sometimes very oligarchic, anti-democratic directions. And many of these shifts in anti-democratic oligarchic directions are really not visible, and people aren't paying attention to these shifts. And you see with the Governor Walker case in Wisconsin, how he accumulated quite a bit of power for himself during that era. And then when he was when he left and a Democrat took over, then they tried to take away power from the governor, the Republican legislature. And so there's kind of these anti-democratic moves that are being made. And they're being made in states in which they are mobilizing people to think about issues in perhaps overly simplified ways in which misinformation and disinformation is contributing to the opportunity to engage in much more oligarchic types of lawmaking. And so I think one of the solutions I think was raised by EJ is terms of democratizing our electoral process, right? Creating opportunities for majorities to truly rule. Virginia is a case study in which they tried with their commission. The commission wasn't well designed, and ultimately the courts drew the districts, but it's a step in the right direction. We have Michigan, which has moved in a direction towards democratic control over the legislature, which would not have happened in the absence of a commission that drew the districts. We could see that by what happened in Wisconsin, which was potentially going to be a supermajority Republican legislature, despite the fact that the Democrat won the statewide office for the governor, right? And so one of the ways, and then what you do with sort of democratizing the process is that you encourage or you incentivize mobilization and engagement with the people. And mobilization and engagement is our primary means of distributing political information right now. It's by candidates knocking on people's doors and engaging them in town halls or holding rallies, is by means by which you can inform people about the issues in ways that will create a little bit more complexity and deeper understanding of what's going on. I think that those are the means in which you can have that sort of positive motivating effects from greater democratization in states.
Quick comment. On that question, I mean, to me, the solution to that is not a legal solution per se. It's for the teachers in Virginia to say, we're going to keep teaching about MLK Jr. There's a damn national holiday named for this guy and monument, near the mall. I've taught a lot of high school teachers over the years in various seminars. And they are mostly progressives, the ones who teach history at least. So to me, that's something the person from the NEA who introduced this, can maybe talk about that later on. But I think this is a clear case where, again, democracy, the large majority of history teachers in this country would like to teach about what really happened in US history and not teach a 1776 project version of it.
Sabeel.
Just quickly on this, maybe kind of connecting Sumit and Osi to your question, sticking to history again, but I think it's always interesting to me, those instances where we have historically sort of bootstrapped structural constitutional change without, but just short of like a formal amendment to the federal constitution. So part of the progressive era mobilization impact was also like the statewide constitutional changes to create ballot referendum process, direct election of senators. That's when you start to see like fights over home rule charter powers for cities to then do the kind of city level policy reforms that I was talking about before. It's not federal constitutional change, but these were sort of like pit stops along that way that were important to changing sort of the balance of power. And so it's not quite a legal remedy, but it is something at a state and local level that changes what's possible in what follows, right? And so I think that's like worth thinking through,
Well, I was just going to add to that because I was thinking about state constitutions as well, is that there might be a legal remedy there. Right. And I'm not familiar with the Virginia Constitution, but a lot of what's happened in terms of electoral reform, democratic reform in the states has been based on state constitutions rules. And a lot of state constitutions have provisions about free and fair education. And so they tend to be much more prescriptive and much more progressive than the federal constitution.